Which special measure? A guide for adults giving evidence in cases of rape or sexual assault. This video is for people aged 18 years or older who've experienced rape or sexual assault in England and Wales. It explains the different ways you can give evidence to the police and at court, if the case goes to trial. This includes special measures, such as the video-recorded police interview, screens, live link, and video-recorded cross-examination. It's important to remember that the judge must give permission for you to use special measures. Special measures may help you feel more comfortable when explaining what happened, and may help you give your best evidence. But special measures may not work for everyone, and you don't have to use them. This video is designed to help you decide which way of giving evidence might work best for you. This video is in 4 parts. It starts by explaining the order of giving evidence. Then, it deals with giving evidence to the police and special measures available at court during cross-examination. At the end of the video, there are things for you to consider about using special measures. The order of giving evidence. Normally, there are 2 stages of giving evidence. First, when you explain what happened to the police. And later, if the suspect is charged and the case goes to trial, when you're asked questions at court. This includes questioning by a defence barrister, which is called cross-examination. Now let's look at ways of giving evidence to the police. When you first explain what happened to the police, you'll do this in a police interview. Your interview can either be video recorded or written up into a witness statement. So what's the difference? The way you give evidence to the police can affect how you give your main evidence in court, if the case goes to trial. Your main evidence is called examination in chief, or evidence in chief. If you make a written statement, you'll need to explain to the jury what you told the police in your statement. This means you'll give your main evidence live during the trial. If this happens, you'll be taken through the evidence you gave in your statement by a prosecution barrister. You'll read your statement beforehand to refresh your memory. And you may also be able to use a screen or a live link when giving live evidence in chief. However, if you video record your police interview, you won't normally have to give your main evidence live during the trial. The video of the police interview can be played to the jury as your evidence in chief instead. This can be helpful, because your memory might be better at the time of the interview than if you wait to give live evidence at the trial. But video recorded evidence can sometimes be poor quality, or difficult for the jury to see or hear. Some people think it's easier for the jury to understand your main evidence if they see a barrister take you through it, rather than watching your police interview on video. Some people make a written statement because they don't want their evidence captured on video, shown to the defendant, or played in court, where the defendant and public will see it. They prefer to give live evidence during the trial from behind a screen, so the defendant and the public cannot see them. This way, they should only be seen by the judge, barristers, and the jury. Now let's look at special measures available during cross-examination. There are 4 ways to be cross-examined at court: without special measures, behind a screen, using a live link, or video-recorded cross-examination. So what's the difference? You can go into the courtroom and be cross-examined during the trial without special measures. You may prefer this if you want the defendant, the public, the judge, barristers, and the jury to see you. Or you can go into the courtroom during the trial and be cross-examined using a screen around the witness box. This means only the judge, barristers, and the jury should see you. The defendant, the public, and the jury will normally leave the courtroom before you enter or leave. You may also be able to use a different entrance, so only the judge and barristers should see you go in or out. If you don't want to go into the courtroom, you may be able to give evidence during the trial using a live link. You'll be in a different room inside the court building, called the witness suite, or you could be at a different location, such as a Sexual Assault Referral Centre, or SARC. The live link allows you to see and talk to the judge and barristers in the courtroom, and they can see and talk to you. The defendant, the public, and the jury will also see you on the TV monitors in the courtroom, but you shouldn't see them. If you feel unable to go into the courtroom or give live evidence during the trial, the prosecution barrister can apply for you to video record the cross-examination. This takes place before the trial, at a separate hearing known as a Section 28 hearing. You'll be in the witness suite or at a remote location and can communicate with the judge and barristers in the courtroom using the live link. The Section 28 hearing is recorded in the absence of the jury, but the defendant and the public will see you on the TV monitors in the courtroom. After the cross-examination is recorded, it is played to the jury at trial. The defendant and the public will also see the Section 28 video played at trial. Remember, however you're cross-examined, without special measures, behind a screen, using a live link, or video-recorded cross-examination, the defendant is normally in the courtroom. Things to consider. Which special measures can I use together? If you video record your police interview, you may be able to record the cross-examination, or be cross-examined live during the trial, using a screen or a live link. If you make a written statement, you'll give your main evidence and cross-examination live during the trial. You may give both parts of your evidence using a screen or a live link, but you cannot video record the cross-examination. So you must video record your police interview if you want to be able to video record your cross-examination. Can I have whatever special measures I want? No. The prosecution barrister must apply to the court to ask if you can use special measures. The judge will listen to your views, but always makes the final decision. Video recorded cross-examination is sometimes more difficult to apply for than other special measures. This is because it takes place before the trial and can be more difficult to organise. Can I be seen by the defendant or the public if I record any part of my evidence or use a live link? Yes. There are TV monitors either side of the courtroom that play the videos or link to the witness suite. The prosecution barrister can apply to screen the monitor opposite the jury and turn any others off, so only the judge, barristers, and the jury should see you. This is called a combined special measures application, or screening the screen. The judge will consider the request, but doesn't have to grant it. Some people make a written statement and give both parts of their evidence live at trial from behind a screen to prevent either part of their evidence being recorded, shown to the defendant, or played in court. Can I have someone with me during cross-examination? Yes. The prosecution barrister can ask the judge if you can have a supporter with you in the courtroom or the witness suite. This could be someone from the witness service or an independent sexual violence advisor or ISVA. They may accompany you, but cannot help you with the evidence itself. What happens if I record both parts of my evidence? If you video record your police interview and cross-examination, you cannot change your mind and later decide that you want to give live evidence during the trial. You'll be cross-examined sooner, or before the trial, but you'll still have to wait until the trial ends for the outcome. Remember, even if you've recorded all your evidence, it's possible that you could be called to give further evidence near or during the trial. This could be because new information arises, the case changes, or there's an issue with the video. But if you do need to give more evidence, the prosecution barrister can apply for special measures to help you. Sometimes the jury can't decide if the defendant is guilty or not. And there can be a retrial with a different jury. If this happens, you may not have to repeat your evidence. If nothing changes, the videos can be reused and played to the next jury. Ultimately, there are different ways of giving evidence, because everyone is different. People's concerns and situations vary, so think about what might help you give your best evidence. For further information, a leaflet has been produced alongside this video. You can arrange a pre-court visit to learn more about special measures by contacting the witness service. To find an ISVA near you, visit the Survivors Trust website. If you've recently been raped or sexually assaulted, you can access your local SARC for medical and practical support on the NHS website. If you just want to talk, you can call Rape Crisis Free on 0808 500 2222 or use the free online chat service on their website. Both services are available anytime, day or night. More information about giving evidence can also be found in the Rape Victims Guide on the CPS website.